Hello, hello, hello. Morning, everybody. I'm starting to worry.
Good morning.
Hey, good morning. Give it a few more minutes and see how many people show up. We usually have some stragglers come in. I'm going to share some documents with you guys today that you should be seeing coming in your inbox here for electronic signature in the next, I'm going to start rolling them out this week. Um, and there's going to be three different forms. So we're going to wait and see how many folks we have jump in here this morning. I'll do the recording and send it around. I'm gonna do a recording that shows the actual forms so that people again know what to expect in their inbox. Um, and I'll send that document out by email or by text. We've been using text messaging and email to communicate just because I know that some people respond better and doesn't get lost in their inbox if it's on a text message. Um, if I haven't gotten any negative feedback from that so far, so we're going to continue to persist on that front, just to make sure, because as the group grows, um, the more important regular communication becomes. Hey, Daryl, welcome.
Hey Joe, how you doing, man? I've been incognito for a little bit, but I'm back.
Yeah, no worries, no worries. I've been slugging through this. The government asked for and got another enlargement on its response to our appeal. So their response is due the first part of June, like I think June 3rd. Um, that's there. This is happening across multiple jurisdictions, multiple different cases. I've got a case in the Fourth Circuit. They had a big shakeup in the DOJ, which should surprise no one. But as a result, they're asking for extensions of time on pretty much everything. There's Ignatius. All right. Hello, Ignatius. Um, so what I'm going to do this morning is I'm going to show. This is a lot of you guys are my regulars. If anybody is new to this group or hasn't joined before, welcome. Obviously, I'm Joe Whitcomb, founder and president of Whitcomb Selinsky PC, lead counsel on these, what are now essentially going to be, I would say two cases, but it's actually going to end up being hundreds. And I'll explain that it probably, I should say, it'll be on behalf of hundreds, maybe eventually on behalf of thousands, but it's going to also end up being in multiple jurisdictions. And this is one of the messages that I've got to get out, because one of the things that we'll need to know when we bring the eventual claim is we have to know the state that the individual plaintiff lived in at the time of the government's malfeasance. When the government acted improperly, we need to know where you lived when that took place. So if you lived in Texas, so we've got some Radio Free Europe folks. They may not. They're eligible for the FLSA claim because they were employed by a U.S. agency at the time, and they fell under federal law. To fall under state law, you have to have lived in a state at the time that you were working for either the government or the contractor that was engaged in employment law violations, misclassification, overtime theft, whatever it was. So that's the information I'm going to have to get from everybody. And when I send out the engagement letters and the form, so there's 3 forms that you're going to get, and I'm going to show you guys what those look like today. If Marie gives me her permission, because she's one of my named plaintiffs, I'll use her form as an example for you guys to see. I won't show you guys the numbers necessarily, but I'll let you guys see what the form itself is going to look like, because I'm going to send that out through my electronic signature software. It's going to come out one at a time because I don't have a way to send 200. We've got about 200 people so far that have filled out those forms. I think the final number with the group that we currently have should end up somewhere around 350 folks. I have found at least one person that signed up for this round of things, the Federal Tort Claims Act, which is code for the state-based claims, that had not signed up for the original Lambert case. So I'll have a conversation one-on-one with that person to see if they want to opt into that case. But the cases that we're moving forward with now are in your individual names, and they're going to the state agencies. And a vast majority of you have signed up for USCGM folks. There's a whole bunch of state laws that I've told you that the government has run afoul of, or you're maybe, whether it's Techniarch or whoever it was that was employing you that ran afoul of. But we're putting all of that at the government's feet because we're arguing that the government was the one who actually, made you work overtime without a way of paying, without a mechanism for paying you for that time. So we're arguing they constructively violated state law by the things that they did. So I'm going to go out here and grab one of these forms, and then I will share with you what that form will look like without giving away any state secrets on the individual claim. So Marie, I just want to take my hat off to you. You've done a good job. I think you've put some, we've added some documents to your collab space. While I have you on here, Marie, were you able to access that collab space that I sent over to you so that you could see the documents we currently have on file? That's one of the other things I want to cover this morning is how we're going to share documents.
Yes, I did.
Good. Good. So we've been using 2 different suites of software, guys, and I hate to bog you down with all of this because I know it can be a little bit complicated, but you guys have been hearing from me very regularly through the Clio portal. That portal, that Clio is our case management software. All of your information currently resides inside your own individual case inside of Clio. And that's how we record, communications. That's how we, communicate to you. We do have a mechanism for storing documents there, but it's a little bit clumsy. Then separately, we have this product we use called Net Documents. It is purely a document management software. And I'm going to show you guys right now what that looks like. And again, I'm not going to show you any individual documents. Marie, if you'll say it's okay, again, I won't open any of these documents, but I want them to be able to see what the actual portal looks like if you're okay with that.
Yeah,
I have other
that's fine. That's
yeah.
fine.
All right, yeah, let me show you guys. And you guys tell me if I hope you're able to see what all of this looks like. So this is what the FTCA, this is what the document portal looks like. And this is a collab space. What you'll get from me, and you'll get it one at a time, these are invitation. You'll get an invitation that says, access this portal. And then you'll have to, I think sometimes you have to, Marie, you can tell me if this is true because I've never been on the receiving end. I send instructions for you to reset your password, which is really just setting it for the first time. And that gives you access to this portal.
Yes, yes,
Okay.
yes. I did reset it. Yes.
That's right. So once you reset it, then this becomes your portal. And I can share everything that we have, that you and I, any of you and I are exchanging in this collab space. You can see it. You can add stuff to it. The only thing the only permission that I withhold is the ability for you to delete things that are in there, right? Because once they go in there, I need them to stay because we have rules with the court as far as spoliation and things like that. But this is what it's going to look like. And then I'm going to stop sharing because I want to find a document that I can show you that look what the documents you're going to be seeing come over are going to look like. And I've been using, just so you all know, full disclosure, I've been using some really sophisticated AI software that's legal AI software. It's not, ChatGPT or something you can get, for free on the internet. This is a product called Harvey.ai. It is built by lawyers for lawyers. It's connected to LexisNexis. I can create these giant knowledge-based portals, and it's enabling me to create these documents very, very quickly and very thoroughly. And pull in the legal precedent, and then I use LexisNexis to make sure that the law is all solid and all of this. And this is what you're going to end up seeing when it's all done, because you're going to get three documents. One document is just an engagement letter. And now you're going to say to me, many of you are going to say to me, and I'm going to make sure I say this intelligently on this call, hey, Joe, I already have an engagement letter with you. And you're right. That is for the FLSA action, the Fair Labor Standards Act action over at the Court of Federal Claims. This engagement letter is for a separate pot of money that we're going to be getting from the government related to state-based claims. So I think I've explained this in every video, but I want to explain it again. As it relates to the case that we have at the Court of Federal Claims, the only recovery we can get from that claim is lost overtime, lost minimum wage, and your attorney's fees for having to recover that lost minimum wage, that lost overtime. And the figure is multiplied by 2. So if the government owes you, $10,000 in overtime pay or $10,000 in minimum wage pay, and I'll explain the difference between those two, beyond what is intuitive, right? Then that $10,000 gets multiplied to 20. And then the cost that you have to pay your attorney, which is me, to recover that money is also added on top of that. So that's what is available to you in the Court of Federal Claims case under the Fair Labor Standards Act. Under this case, it's called the Federal Tort Claims Act. This is a claim that you file against the federal government for violating state law. So the example I've probably given here, and I give a lot of times, is you're driving through an intersection and you get hit by a U.S. Postal Service truck, right? And you suffer injuries. Normally, the government under the Constitution and under ancient, it's actually Old English law, the government is immune from a lawsuit in that kind of instance. The way that the government can and has waived that immunity through what's called the Federal Tort Claims Act, which means it subjected itself to state law violations. The violations we're alleging here is that each and every state in the union has different laws that make, for example, misclassifying employees as contractors illegal. It also has separate damages calculations. So it's not just missed overtime and minimum wage, but things like it makes a comparison between what you got paid as a contractor versus what you would have gotten paid had you been properly classified as a W-2 employee. And that is a very different calculation of damages. Here's the other really fun fact. Every document that you guys see, every Form 95 that we submit to the U.S. government is required to have a sum certain. So you're going to see when I send these documents to you, you're going to see a number. Maybe it'll say 125,000. Some of them may say 500,000. Some may say 600, whatever it is, because the computer, the software that I'm using, computes your damages based on the allegations that you put in that form that I sent you, which is why it's very important that. And again, I'm going to continue to supplement this. So I'm going to continue. While one of the reasons I open up this portal for you guys is to add any communications that you might have had with the government actor or with your private employer, to put all of that stuff in here, right? So that we can use that information to help calculate your total damages. And then when we send that to, the government has to make the decision when we send that over to say yes or no to those amounts of damages. So I'm going to show you here, like I'm getting into some software. I'm going to show you where, claim records. All right, let me see if I can open this and share it without. That's not really. All right, I'll find one that's got more information. All right. Just a minute. All right, I know what to do. We need to go away. All right. Give me just a second, guys. I'm pulling that up for you to see. My computer's moving kind of slow because of this. Because of our Zoom call. All right. Okay. I wanted to be able to show you guys this, and I have one here, but Oscar's not here. Let me see who is here. Daryl is here. Let me see if I can find one. It's got Daryl's name. All right, I am falling flat here, guys. I want to be able to show you this. I will get a screenshot of this, what you guys are seeing, and I'll pass it around because my computer is just taking a really hard time having a hard time loading this because I have so many people on this call. I'll send out what it looks like. But what you need to know is there's three documents. One is a Form 95. It outlines your claim against the United States government. The second form is an engagement letter, which has the engagement letter for the Federal Tort Claims Act. Now, what you need to know about that is that the amount of the percentage that an attorney is allowed to take under that claim as far as a contingency fee is regulated, is controlled by statute. So like in the engagement letters that most of you have signed now with the FLSA action, it's 33% of the total recovery as we, and we only get paid again if we recover, and that's at the FLSA action. At this action, at the Federal Tort Claims Act claim against the state or against the federal government under state law is limited to 20% if we recover at the agency level, and 25% if the agency denies your claim and we have to go to court. And again, let's say in that instance the government comes back and says, "Hey, we will agree to settle both claims, right, under for the FLSA and the FTCA as against Marie for this amount of money," right? Marie is the only person that gets to say yes or no to that, not me. Right. So, and if it's what I tell you guys, what I've told you guys from very beginning back 2 years ago is if the thing that's standing in the way of her being able to say yes, usually if somebody's in Marie's shoes, she'll look at what she was going to recover after I get my fees. The government is responsible for paying the fees under the FLSA. Right. So we're going to get the government to come in and negotiate with the government to pay the fee, so that the idea is that Marie or Alana or Mohammed gets to walk away with the amount of money that they were deprived of without having to take a haircut because they had to hire an attorney to get there. Hopefully that makes sense. So the idea is that you're not required in that instance to what I'm trying to say is you're not going to ever be forced to double dip on contingency fees. And the second thing is, in other words, you won't ever pay more than say 25 to 33% of the total amount recovered on any or both cases. So you're not going to pay 25 and 35 on top of one another. That's not going to happen. It'll end up being a blended rate between the two, so that your total recovery ends up being somewhere between 67 and 75% of the total amount of money that we recovered for you guys. And here's the thing: we're not just trying to collect what they deprived you. That wouldn't be really fair. That would sound like you waiting 5 or 6 years or 10 years for some of you for the amount of money that you were due 10 years ago without any interest or penalties. And that's not the way these work. They have interest. They have liquidated damages, which means the government would be, if we're successful, the government would be required to pay you, like I said, the $10,000 a day, or 10,000, then it turns into 20. And by the way, most of these claims that are coming in high 5 figures, low 6 figures, some are mid 6 figures. But each of you will get an opportunity individually to look at the amount of damages that we're trying to recover from the government under these FTCA claims, which is different from the Fair Labor Standards Act case, where we're having to basically lump everybody together into one case and try to get the government to write one check and then try to divide it out after the fact. Under the Federal Tort Claims Act case, everybody's claim lives and dies individually. Hopefully that makes sense. I've said a lot of words, as is my habit. I've been going for about 20 minutes. I want to do what I always do, which is to open up the rest of the morning to questions. There's not a big group of you, but you guys usually have really great questions, and then I redistribute these videos to everybody after the fact. If you guys remember our normal courses, to use the hand raising feature at the bottom of your screen, and then I'll call on whoever has their hand raised. All right, I don't see any raised hands. Let me see if I've got, all right. Here's what I'm gonna do. I know I have Jason's pretty much continued cooperation on this. He's always let me do whatever I needed to do in these cases. So here's an instance of what these things. All right, we got Ignatius with his hand up, and looks like Mohammed had his hand up first. So Mohammed, go ahead.
Yeah, I have a quick questions.
Go ahead.
In the forms we filled when they substitute our contract, and the majority of my coworkers, they went with the agency which hired with VOA. But I decided to stay as a subcontractor for myself because I didn't like the the contract terms with Netco. So
Okay.
I was able to maintain the same amount of money I was receiving with VOA, contrary to other coworkers. But I had the same problem like the Dakota because I didn't have any vacation times, no sick leave, and we work overtimes without pay, and holidays was not paid. So is that going to be different with other contractor because I was a subcontractor?
No. So again, this is something that's really important for me to say to you guys. How, whatever, the fact that you signed a contract is not material to the question of whether or not your employer misclassified you, right? And also because remember, a lot this contractor issue is a defense mechanism for the employer, right? So the example I give all the time is Mohammed, you come to work for me as a paralegal in my law firm, right? And even if you come into my office and you're like, Joe, you know what, man, I've got my own little side hustle going here. I want you to bring me on as a 1099 and pay me cash because I don't like paying those pesky FICA fees or whatever, and I'll pay my own self-employment tax. I'm going to write down a part of my house, and you give me all these great reasons for making you a 1099, right? And we agree to it. We shake on it. We put it in writing, and then I work you 100 hours a week. Let's say in that instance, I work you 50, 60 hours a week, and you don't have time to go work for anybody else. And you're like, hey, by the way, Joe, since I'm an independent contractor, I'm going to send my good friend Marie to come in every now and again and be the paralegal instead of me. And I'm like, nope, Mohammed, it has to be you, right? And then later you're scratching your head and you're like, you know what, I got a really bad deal here because didn't intend to work 60 hours a week when I said yes to Joe. And he worked me so hard. I didn't make any overtime and I didn't get any bennies. All the other people that work in there got benefits. And you go and you sue me and I file an answer and say, well, look, Muhammad and I had a contract and he agreed to be a 1099. In fact, he asked me to be a 1099. The courts do not care because the employer is charged with, following the law. Many people, right? And a lot of it, look, the government has an interest in that. A lot of people would be very happy to, have me pay them cash, right? They can sidestep taxes maybe, or, whatever. The government says no. The law says no. The law says, employer, you have to pay this person as a W-2 employee if they satisfy the criteria of being a W-2 employee, which means which is all the things we've talked about like many, many times, which is in this questionnaire that you completed, which is if I'm telling you when you have to be to work, I say, Mohammed, you need to be in my office between 8 and 5. You need to turn out this much work. I'm going to measure you got to use my equipment. I don't want you bringing in your own laptop. You got to use my equipment, right? I don't want you using your own software. I want you to use my software. And you can't send anybody else in your stead. You have to be the one coming in. Then you are, by definition, a W-2 employee, which means that all of the things, and this is what I'm going to bring up right now. I want you guys to see what this looks like because
That was exactly what they did to me because the manager, the chief of the service told me I have to do myself the job. I cannot hire anybody to replace me.
Of course.
And the contractor, which is Netcom, tried to give an advantage based off my experience and all this stuff. They tried to increase my salary, but VOA chief, the service of where I was working with, he said, no,
Of course,
you're going to have to be just pay like everybody else.
right. Yeah.
I
So,
remember,
yeah,
and then,
that, Mohammed, that's the government trying to get the best of both worlds, right? No, you're an independent contractor, you don't get any benefits, but we need you to work. We need you to be the one doing the work. You can't farm it out, right? And so, like, if you have, but let's say you own a paralegal company and you have 20 paralegals working for you. And I'm like, Mohammed, I need a paralegal to come work for me, right? I need a paralegal. And you say, Joe, how long are they going to work? I'm like, they're going to work 40 hours a week, right? But I say to you, and this is how this typically looks, Mohammed, I need you to agree to supply a paralegal to me for $4,000 a month. Period. I need you, Mohammed, I need you to commit to $4,000 a month for a paralegal. And you're like, sounds like a deal, Joe. You're only going to work them. You're only going to work them. And I'm using terrible numbers, but you're only going to work them 40 hours a week. I'm taking you at your word. So I'm going to provide you one of my best paralegals. Marie's going to come be your paralegal, right? And great. We sign a contract, you and me. You hand Marie over to me to come work as a paralegal. And I say, Marie, I need you here at 8 o'clock. I need you to work till 5. And she comes in and she does the work. But then I put a pile of work on her desk. And Marie, this will resonate with you because this is actually what happened to you, as I understand the story. I put a pile of work on her desk that no human being could do in 40 hours in a week. I need her to do, 18 depositions this week. I need her to do all this work that no human being could do in a week. And Marie comes to me and she's like, hey, Joe, I need more people to do all this work. I can't do this in 40 hours. I'm like, Marie, go talk to Muhammad. It's not my problem. So you go talk to Muhammad. Marie goes and talks to Muhammad. Muhammad comes to me and says, hey, Joe, you told me 40 hours a week. I'm like, yeah, I know. And you shook on it. Here, you signed this deal. Well, Marie can't do that work in 40 hours. I say to Muhammad, this is all what happened, by the way. I'm doing real live role play as to what actually happened. I say to Muhammad, hey, Muhammad, we signed a contract. That's not my problem. You and Marie have to figure out a way for her to do that work in 40 hours. Or if you're going to pay her, if she works over 40 hours, Muhammad, that's your problem. You got to pay her for that overtime. And Muhammad would rightly say, hey, Joe, that is not what we agreed to. You agreed to 40 hours. Yeah, Muhammad, that's not in the contract anywhere. Look at the contract. It's not in the contract anywhere. You agreed to a firm fixed price contract. And I didn't disclaim any. And that is exactly what the government did over and over and over and over again. Does that all make sense? That is why the government doesn't get to put blinders on and say, hey, I didn't know better, because they did know better. Does that all check?
yes.
Ignatius, your hand is up. Tell me what you got.
Good morning, Joseph, and thank you so much for everything that you do. I always find your sessions insightful. Just a quick question for you. Last week, I had a message from one of the VOA former employees, FTE for that matter. It was basically a message from a law firm called Gilbert Employment Law. And the purpose of that, a link that she shared with me, was the fact that they were collecting information from past USAGM, VOA, their personal contractors and FTEs. I just want to know if this has come to your attention, because it looks like there are other law firms who are trying to get ex-VOA USAGM employees on the same thing that you're doing. Has this come to your attention? What should we do with these things that are coming up, if you're aware of it?
Well, here's what I'll tell you, Ignatius. You always have the right to hire whoever you want to be your lawyer. Always, right? Like, I'm never gonna. I will tell you that going into the federal torts claim. What am I trying to say? The FLSA Act that we have at the Court of Federal Claims. That is the only court that particular overtime wage theft claim can be filed. And if anybody, let's say you left my case and you went and hired another attorney and they filed a new claim, you could be theoretically resetting your damages picture to only reach back 3 years from when you filed. Is that from, like, let's say you file tomorrow, that could theoretically cut off your damages to only go back to 3 years from tomorrow, which would put you back like in 2023. The current claim as it sits goes back to 2021, and the appeal that I have filed has it going back forever. That's the argument I'm trying to make. So now as it relates to the FTCA claims that I'm currently doing. Again, there's no, I mean, look, I want to represent you guys, and because I've done a lot of work on this, and I've kind of again sort of accidentally created this area of law, but also I sue the government for a living. But your recovery is your recovery, and there is, I can't tell you, and I wouldn't be tempted to tell you, you can only choose from one lawyer. One of the things that like I do, and one of the reasons I have some language in my engagement letter that I have is to protect me from, say, you sign up with me today and we go all the way to the courthouse steps, and then the government shows up and says, you know what, I agree to pay Ignatius everything he asked for, right? I'm going to give him everything he asked for, and I need you to, they can't ask you, so they'll come to me. And I bring that deal to you, and I'm like, hey, Ignatius, good news. The government's agreed to pay you everything that you asked for, make you whole, and pay my attorney's fees. And you're like, Joe, great. I appreciate that. And then you go across the street to your family lawyer who's been your friend forever. And you're like, hey, can you step in for Joe so that I don't have to pay Joe? That's what my engagement letter protects me from. My engagement letter protects me from you going across the street after I've done all the work to another lawyer who says, hey, Ignatius, Joe's charging you 25% or I'll do it for 10. So that's the only thing my engagement letter really protects me from. But if you decided like, hey, you know what, I think this other lawyer or something, or anybody decides, I think this other lawyer can do a better job, that is always your right. I will, if you ask me, I will tell you that I do this as well as anybody does. And I know the factors that play into this, and that no one before me has ever tried it. So you can go with the individual who actually, again, sort of invented this thing, or you can go with the inventor, or you can go with a copycat. And I bid you Godspeed, whoever you choose. My job is to advocate for you and to tell you, why I think I'm the best choice. But it's kind of like, the candidate for any job. You guys are the employers. You guys employ me to do a job. And I always tell any client who hires me, being your lawyer is the most at-will employment in the world. I'm your lawyer for as long as you'll have me. Once we get, it gets a little, once I've submitted your claims, you could weaken your case by substituting counsel, because then the government defendant starts to smell blood and water. And they start, oh, well, let me see if I can put a wedge between Ignatius and his lawyer, or Daryl and his lawyer, or Marie and her lawyer. Then they'll try to leverage that. But look, you always, and I work with other lawyers. I'm working with another lawyer on this case. I'm working with Forrester Haney on this so that we can have more bandwidth, more people, because we expect once I dump 300 new claims on the government in a dozen new states, I expect them, to the degree that they have the manpower or staffing, they're going to throw as much at us as they can. And so I'm building up my team to make sure that we can still put up a good fight. Right now, like we're currently today in April of 2026, we're in a little bit of an advantage because the U.S. Attorney's Office and the Department of Justice is going through just major shakeups. So we're at a little bit of an advantage right now, and I'm trying to take advantage of that advantage. Like I'm trying to take advantage of that window by getting all of these claims filed now, while the government is a little bit weak from being able to respond. Did that answer your question?
You did, Joseph. Thank you. And also, just to be clear, I raised this because I found the email confusing. For the most part, as a contractor, wasn't born in the US, so there's certain information that I still knew, and I want to make sure that I'm doing the right thing. And also not to be overwhelmed by any of these legal issues that are coming up. And so that's why I asked the question. Just to be sure, I know that I am on the right path. I believe in your counsel, and I trust that you have been doing what is right by all of us. So I just wanted to have that clarity and not get overwhelmed with these things as they come.
Listen, you're 100% fine. And I want you guys, you bring up another really valid point, Ignatius, is this. The form that you completed is really just the seeding for the beginning, right? So I'm using that information to bring it in. And then again, I've got 50 different states. I don't have 50 different states I'm working with now. I feel like I'll eventually have 50 states. But right now I'm working with you guys. The folks that are in this case so far represent about a dozen different states in the union. California, Virginia, Georgia, Washington, D.C., Maryland, obviously. I've got a couple of New York folks, right? So the point I'm making is that I bring this form in. I bring in any documents that you currently have. That's why I'm opening up these portals and emailing them to you, right? And then I'm about to share with you what you will eventually see come over in your right here. I'm going to show you. This is what. All right, this is Lambert. This is Jason's, who's is public. But now you're seeing what this is going to look like. So the first form is a sworn declaration. This is all the things that you guys wrote in this form that I'm pulling over to the sworn declaration that you'll sign here. And then the second form is a form standard form 95, a claim for damage, injury, or death. That document you'll see that shows out, and this is one of 3 state agencies that were federal agencies that Jason worked for. And then here's the final thing is the engagement letter. And that engagement letter will have, the signature block for you, me, and the folks at Forrester Haney. Now, when you get that, I expect that form will invite, especially the Form 95 and the sworn statement, that should invite questions. When you get it, you're going to like, hey, Joe, I actually worked at VOA from January of 24 or January of 21 or January of 12 or whatever it is. If there's a factual inaccuracy inside that document, we're going to use the Clio portal to back and forth to be able to correct that, right? The other thing is the Form 95 requires a date of birth, and that was one field that I left off. So I'm going to inject that form into the document, and I'll make it a required field. And when I send it to you to complete, you'll throw in your date of birth, throw in your signature, and we'll have a complete document. But when I send these documents to you for review, the idea is for you to review them and be like, yeah, this says everything I needed to say. This covers all of my damages. It shows all of my agencies, everything that we need. Because if there's, like I said, with Jason, he worked for, and I know he won't mind me telling you, but he worked for state, DOJ, and VOA. So we have 3 different claims to file against 3 different agencies because you have to sue each individual agency separately for their bad acts. So some of you had, I know I saw others of you who had multiple agencies that you worked for over the years. The other thing is the government will say, well, look, you can only go back 2 years. We're going to also include a motion to enlarge the statute of limitations on this case, just like we have the others, because we're going to argue that the government is equitably stopped from arguing the statute of limitations because they flat lied to you for as many years as they lied to you. Does that all make sense?
It does. Thank you, Joseph.
Of course. And he goes, if I showed you guys briefly that document, just so you guys would know what it looks like. When I send it to you, again, I'll include instructions to please review it, catch any errors that might be in it from like the time that you work, look at the amount of money that I'm asking for, because one of the things that's important to know in this Form 95 is if whatever we ask for, we can always accept less, but we can never demand more. So if we put $1 million in that form or $100,000 and they say yes to it, that ends your claim. If they say no to it and we go to federal court, the most we can ask for is the amount that we ask for in that Form 95. We can't. So I always hedge in by asking for more money than, not a lot more money, but at least slightly more money than we think we could theoretically get at court, so that because it's always easier to negotiate down, you cannot negotiate up on these claims. Got other people coming in now. Was there any confusion from you guys on I sent a bunch of emails out to you guys this week because I wanted to try to get as many people in this call as I can. If there's ever any confusion in my emails, guys, those go out from me, come back straight. So if you respond to that, like, hey, Joe, this email is gibberish, I don't understand it, let me know. I mean, it won't happen often, but it could easily happen that I got a misspelling or something in there because I write them, I write them from scratch. So, and I cannibalize some previous emails so that I'm not, some of the links and stuff like that. So if there's something in there that doesn't make sense, just shoot me an email back. I'm communicating with a lot of you. Almost all of you, I think, have received communications from me through those, either the text messaging portal or the client portal inside of Clio. That's also a great way. Save that number in your phone, because that's a great way to communicate back with me and be like, Joe, hey, I got a question. And it's awesome because I literally, there'll be a red dot on my screen until I respond to you, or at least until I read the message, which as soon as I read it, I'm going to respond to you. So that's a great way to continue to communicate with me and make sure that your questions are answered in real time. All right. Any other questions before we move? Before I give you guys the rest of
Yes. There's a little confusion. In those 95 forms we answer, particularly the question about the term of our titles, for those who started back in 2013, prior to becoming PSCs,
Yeah.
It was not straight. The question when you ask it, they just ask your title. So in between, I have to make the time I was, a contractor before become converted to a PSC, which is a 2019.
Sure.
So yeah, I don't know how you guys been seeing those answers on the sheet. So.
Well, one of the things and thank you, Mohammed, for bringing that up, because that is the other benefit of that sort of. I left an unlimited amount of space at the bottom, right, on that form for you to, and it's going to get anything you tell me in there is going to get incorporated into your claims, right? So, and it's really because it's hard. There's 200 and 350 of you, so it's hard for me to create a universal form that will answer everything. The things that are in this form are the elements of the claims that I need statutorily to bring a claim against the government. But that final block, that piece where tell me anything else that would be useful, would be a great place for you to say, hey, by the way, in your case, Mohammed, I worked for VOA, and I know this story backwards and forwards because, again, I have this whole case going on in the Court of Federal Claims. But I worked for VOA or USAGM as a 1099, with the government for set until 2020 when they finally moved us over to PSCs. And during that time, I usually worked X number of hours. I only got paid for Y number of hours. And then when I open up the portal, and that's the other thing, really important part of the portal. When I open up the portal, you'll send it to you. You'll be able to literally drag and drop every communication you ever had that you still have in your possession, every document they sent you, every contract that they changed. There's literally no limit to the amount of documentation you can throw in there. And then I'm going to pull all of that into my AI software and say, hey, incorporate everything that Mohammed just dropped into this portal, edit this document and create a new one. And that's why we're not going to have you sign this document. I'm pushing really hard to get these done and submitted by the end of April, first part of May. And I'm making I'm making more progress on that effort than I originally thought I was going to. You guys have been really responsive. You've given me some great information, and I'm moving. Some of the stuff is tedious. I've got to open up an individual portal for every one of you. I've been able to automate a lot of it. I was able to upload a CSV of every one of you into and create a new matter for every one of you. But opening up that individual portal has to be done individually. That's tedious and time consuming. I could probably do 20 or 30 of those a day. I've got my wife, Carolee, who some of you have heard from. She's working as a W-2 for my company now. I've got her properly classified if anyone's curious. And she's sending you guys out emails and texts through the portal and sending you out. And I'm showing her today how to open up those NetDocs portals, because Mohammed, there's really, and again, you guys are going to tell me, some of you have told me already, hey, I don't have access to those emails anymore. That's okay. Don't worry if you don't. If you've got anything that you have saved to your desktop or in your personal possession that relates to those contracts that you worked, drag them over there, because I'm going to be able to use those to incorporate and exhibit when I send your final claim to the government. Does that make sense?
Yes, nice. Thank you.
Perfect. So this is going to be a work in progress. And I'm not going to look, I have my own internal deadlines. I have one in my head, the real cutoff, the thing that I'm really shooting for to try to cut off any arguments from the government is to get all these things actually filed by June. But I want to get them, and I'd love to send a FedEx folder with 100 of them, a FedEx envelope with 100 claims to the government, or 200 or 300 in one day. That would have a lot of shock and awe. But at the end of the day, I'm not going to let that's kind of a vanity race, and I'm not going to let that interfere with actually getting these claims timely filed. So when we open up these portals, I'll send you a message and we'll say, hey, open up, drop as much as you can, as much as you have handy, text messages on your phone, email correspondence, anything that you can put your hands on that are related to those contracts. And my AI will use that and incorporate that into your claims, and then you will see them and you'll be able to fact check them. The law will be right. The law that you see in these things will be accurate. But the factual stuff, you'll want to make sure that you fact check it and make sure that we didn't leave anything out. Okay, everybody?
Yes.
I've still got a few more minutes. If anybody has any more questions, I've still 7 minutes left on our hour. Does anybody have any more questions? I see a lot of our regulars, and I really appreciate you guys joining, because what I'm confident of is every time I do one of these videos and then I distribute them to all 380 or 30 or whatever folks that are on this listserv, that creates some more curiosity. It also answers some questions and puts some people at ease. All right, guys, if I don't have any other questions, I'm going to give you the rest of your Sunday back. I appreciate you guys joining on. And we're going to do this again every 2 weeks. I'm going to be, by the way, this is a PSA. I'm going to be in DC the 3rd of May 3rd. I'm going to be there through the 8th. I know a lot of you live in that area. I'm there visiting. I've got 2 court cases, one on Tuesday and one on Wednesday. One is at the Court of Appeals for a government contractor that I represent. The other one is in Maryland for a probate client that I represent. I will be working with a gentleman I think some of you know, Ari Aramis. She's one of my managers and practice group leaders in the DC area. He and I will be on the ground, getting in front of some of the House members that we're hoping to get some policy changes done through and so forth. So, if you guys have any questions of me, one of these days I want to get in there and do like a town hall meeting and invite everybody in and kind of bring everybody up to speed and help everybody you guys get to see my face on a pretty regular basis, but actually get to meet some of you and hear some of your stories would be fun for me as well. All right, if there are no other questions, I appreciate you guys, and I'll see you in a couple of weeks. I'll get some more messages out, and again, look for these forms to come over, and then it'll be an invitation for you guys to look over them, make sure they're accurate, and send them back to me. Redline them or add some commentary so that we can incorporate them and make them great. All right, talk soon.
Thank you, Joe.
Thank you.
Thank you.
Bye.